What are the three most antagonistic and contentious parts of a medical malpractice lawsuit? Would you like to know the answer? Come join me for a walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, the first and most antagonistic and contentious part of any medical malpractice lawsuit is when we actually begin the lawsuit. That is when we go ahead and fling accusations at the doctor whom you believe caused you significant harm and injury. The second time that there is antagonism, the second time that there is contentiousness, is when I have an opportunity to question the doctor whom you have sued, to get details from him about what he did and why. That is known as a deposition. It's a pretrial question and answer session that takes place typically in the doctor's attorney's office or nowadays on a Zoom video call. That is the second time we are likely to see antagonism and contentiousness. Okay, what is the third time? Here we go, 1, 2, 3. What is the third time that we are likely to have antagonism and contentiousness? The third time is when we go to trial. And now we are in front of a jury of 6 members of the community. We are in front of the court, the judge. And now we are presenting evidence to establish why this doctor whom previously you loved, but now we believe caused you significant harm and injury. That is when we have contentiousness. That is when there is fighting. That is when we have verbal jousting, when we are trying to show that we are slightly more likely right than wrong than what we are claiming is true. And we do that with medical experts. We do that by establishing that the doctor violated the basic standards of medical care, causing you significant harm and injury. Don't assume for a second that just because you think you have a great case, that the doctor is automatically going to roll over and say, okay, let me get out my checkbook. How much do you need to settle this case? No, that's not how it works. In New York, when we first start the case, the doctor is going to get his feathers all ruffled up. And now he's going to relay that information to his attorney. His attorney is going to take a defiant position to us at the very beginning of the case. Then when it comes time to questioning the doctor during the course of a deposition, now the doctor is going to be extremely defensive. And what do you think the doctor would say if I turned around and said, hey doctor, did you screw up my client? Did you do something wrong to cause her harm and injury? What do you think he's going to say? He's going to say, absolutely not. I did absolutely nothing wrong. And whatever I did not cause your client harm and injury. Your client caused her own injuries. That's often what they will do, and those are known as affirmative defenses. So that is another time where we will see antagonism and contentiousness and fighting during the course of the lawsuit. The doctor is simply not going to throw his hands up in the middle of the deposition and say, you know what, Oginski, you're right. I screwed up and I caused your client horrible injuries. No, that's not how it works. And now when we get to trial, don't think for a second that the doctor's going to turn to the jury and say, ladies and gentlemen, Oginski and his client are absolutely right. Oh, no. They're going to argue the same exact defenses that they have throughout the entire litigation. Number 1, I did nothing wrong. Number 2, even if I did something wrong, whatever I did not cause you injury. Number 3, if I did something wrong and I caused you harm, guess what? Your injuries really are not as bad as you claim them to be. So those are the 3 important points during the course of a medical malpractice lawsuit where we are going to experience antagonism, we are going to experience contentiousness. In all likelihood, we will experience significant drama. Why? Because the doctor is going to deny over and over again. And when that happens, we don't simply attack it head on and say, doctor, I know you screwed up. No, I didn't. Yes, you did. No, I didn't. No, that's not how it works. There are different tools and strategies that we use to try and establish that the doctor violated the basic standards of medical care. And I'll give you a quick example. Doctor, I want you to assume that Mrs. Jones came into your office with the following complaint of pain in her left breast at the 12 o'clock position. Would you agree in that instance, good medical practice requires that you take a detailed medical history? Oh yes, of course. Would you agree that good medical practice requires that you determine if this patient has a history of any type of cancer? Yes, I would. Would you agree it's important for you as the physician, now evaluating and examining this patient who comes in with a complaint, to establish whether or not this patient has a family history, whether anyone in her family has a history of cancer, specifically breast cancer? Oh yes, absolutely. And that would be good medical practice, correct? Yes. Now why am I doing this? I'm doing this because I want to establish what the standard of care was. The facts are clear-cut, at least to us. We believe that the doctor failed to recognize and acknowledge that this patient had a complaint of a lump in her breast. It is our position in this particular hypothetical that the doctor failed to inquire about whether this patient had a history of cancer and whether her family members had a history of cancer or breast cancer. And why is that important? Because in this particular hypothetical, there is a failure to diagnose breast cancer, and there's a failure to recognize that this patient had a history of other cancers and had family members who also experienced breast cancer. And because this doctor failed to recognize those things, it now created a snowball effect that now led to a diagnosis of breast cancer many, many months later than it should have. So why is this important? Because when I ask the doctor questions about the standard of care and what is good medical practice, there should be no disagreement. There should be no contentiousness. There should be no antagonism there. The doctor, being well educated, should have the knowledge and experience to be able to articulate and explain to me what is good medical practice and what is the standard of care when a patient comes in with a particular complaint about a lump in her breast. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of medical malpractice cases work in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.